Let's wait a minute and let everyone get settled.
Certainly, Your Honor.
Okay, Mr. Woodruff?
Good morning, Your Honors. My name is Walter Woodruff, and I, along with Michael Ginart and Joyce Young, represent Mr. Andrew Bruno, who is the plaintiff in the district court and appears in this court this morning as appellant. Thank you for the opportunities, Your Honor, to present oral argument. I know Mr. Ginart and Ms. Young join me in extending our appreciation for that. One cannot validly deduce, Your Honors, a cause and effect relationship between two events solely on the basis of observing an association or a correlation between those two events. But that is exactly what the district court did or expected Mr. Bruno to do in this case. This is a Louisiana product liability case that was filed on September 25th, 2020 in state court. It was removed to federal court, and shortly thereafter, Biomet moved for summary judgment and listing a variety of defenses. But ultimately, the district court dismissed the case with prejudice, finding that it was prescribed. We submit that the district court reversibly erred in not finding that the Louisiana doctrine of contra non volentem saved Mr. Bruno's claims. Under that doctrine, prescription is told and begins to run on the date that the plaintiff knew or should have known of the facts upon which his claim is based. I know this court heard argument yesterday in the Jack case where contra non volentem was raised and discussed, so I will dispense with any sort of banal or platitudinous regurgitation of what the doctrine is, because I know your honors are familiar with it. But I deduce from that and from my research that it's always a fact-intensive evaluation and analysis. So looking at these facts, what we know and we know for sure is that on December 29th, 2016, Mr. Bruno underwent a shoulder surgery at Ochsner, wherein the doctors implanted a device into his shoulder that was manufactured by Zimmer Incorporated and Biomet Incorporated, who I have and will continue to refer to collectively as Biomet. After the surgery, Mr. Bruno began experiencing some difficulties. For the next 22 months, he had a persistent and intractable infection. He continued to treat with the same doctor, followed that doctor's regimen, followed that doctor's advice.
Counsel, did he see the same doctor after the removal, the November 1st, 2018 removal?
He did, Dr. Doolin.
With the same frequency?
It was sporadic. I mean, there were different periods. There were apertures in the treatment because he went longer periods without infection, but it always would recur. So he wasn't seeing it on a fixed basis. But yes, every time he had an issue or a problem, he would return to Dr. Doolin's. I think it's fair to say that Dr. Doolin's was baffled by this. He referred Mr. Bruno to an infectious disease specialist by the name of Dr. Mary Joubert. And
After the removal of the device?
No, before.
Okay.
Yes, sir. And they couldn't figure it out. I mean, they treated it with high intensity intravenous antibiotics. You know, the Dr. Doolin's gave shifting explanations for what was causing it, but every explanation, I think it's fair to deduce or conclude that it was topical. One was the sutures that were used. One was
again, before the removal. I'm asking about after the removal. How quickly was his infection resolved?
He did experience some infections after that, but it was about 4 months, Your Honor, after that he was infection free. And he was treating with the doctor in those 4 months. So, on the advice of his doctor, Mr. Bruno was amenable to his doctor's advice that the device be removed, which it was on November 16th, 2018. Some 10 months later, on September 25th, 2019, Biomet sent out a mass mailing informing doctors in hospitals, not patients, that it had been discovered, and they were voluntarily recalling Biomet products, including the ones inserted into Mr. Bruno, because they could have resulted in elevated levels of bacterial endotoxins. Again, Bruno was not a recipient of this letter, but he did, after that letter was authored and received by Ochsner, Mr. David Paulette, the operations manager for Ochsner, sent a letter to Mr. Bruno informing him that the devices used in your procedure were sterilized and therefore could not cause infection. Now, appended to that letter was the Biomet letter. Mr. Bruno never received that Biomet letter independently. But again, Mr. Paulette offered assurances that almost like, pay no attention to that man behind the curtain, pay no attention to this letter, this could not have caused your infection because we sterilized it. So again, some 22 months later, on September 25th, 2020, within a year of the Biomet letter, and certainly within a year of receiving Mr. Paulette's letter, because we know Mr. Paulette's letter was received after September 25th, 2019, he filed his suit under the Louisiana Product Liability Claim. Again, the district court dismissed it based on prescription refusing to apply contra non-volentum, and it is from that ruling we appeal, and we ask that this court, in exercising de novo standard review, reverse the district court. Now, in reversing the district court, I think, and we maintain, that this court has enough information to find and adjudicate that contra non-volentum did, in fact, interrupt and render Mr. Bruno's suit timely. But at a minimum, the court should remand the case for the jury to determine that issue if your honors disagree with me that there's insufficient information to convince you that Mr. Bruno at all times acted reasonably in following his doctor's advice, following up with his doctor, and again, doing exactly what his doctor said.
How much discovery was conducted prior to the motion being filed? Or
So
being ruled upon, I should
depositions
say.
were taken, Your
Okay.
Honor, and that's a critical point, and I'm glad you asked the question, because at no time does Dr. Doolins ever say he suspected that this device was what was causing the problems. And I know that courts consistently consider the reasonableness of a plaintiff's action or inaction, and that's always based on the information that that person had at that time, and you look to the person's intelligence and education. Mr. Bruno at the time was 70 years old. He has a high school education. He's a layperson. He's an air conditioning repairman. And again, all he knew is he was suffering. He was reasonable and dutiful in presenting himself to the doctor and following that advice.
Tell us specifically, and this is repeating what you've already told us to some extent, specifically what does the record show about what his doctor told him to the effect that the infection was due to something else, caused by something else?
Certainly, Your Honor. If I can get to that page. And that's the crux of our argument is I think the learned district court judge failed to adhere to what this court has instructed many times, and in fact what the Supreme Court has commanded, that all facts are to be viewed in the light most favorable to the non-movement.
No, I'm not asking for all that recitation. Just tell us what's in this record about what the doctor told him.
So Dr. Doolins, Mr. Bruno's surgeon, testified that the surgery implanting the device was successful and no immediate complications were noted. That's record page 399. Given the nature of Mr. Bruno's drainage, his surgeon believed that a skin contaminant was the likely cause of Mr. Bruno's issues. That's record 405. Mr. Bruno's surgeon explained to Mr. Bruno that his symptoms appeared to be a reaction to some type of suture that closed the subcutaneous tissue. That's record pages 413 to 414. Mr. Bruno's surgeon also said that he inspected the device as it was implanted and determined that it felt normal with no evidence of any infection. That's record 422. Mr. Bruno's surgeon further testified that he felt the infection was superficial and not due to components. That's record page 423 through 425. And again, the letter of Ochsner's operation manager advised Mr. Bruno that the device used in his procedure could not have caused the infection. So those things we think, Your Honor, make it reasonable for Mr. Bruno not to.
What's the record site for that last one? Could not have caused the infection.
1595, Your Honor. And so when you look at what he knew, and 4 months, and again, he still had complications even after the device came out for about 4 months, but after that period, it marked a recovery. He wasn't looking to blame anyone. He wasn't looking for anyone to sue. He was just happy that he wasn't having these problems anymore. So when you look at the district court's judgment and you look at some of the word choices, I think it's evidence of how he departs from the proper summary judgment standard, where he did not view facts in the light most favorable to Mr. Bruno, nor did he draw reasonable inferences in favor of Mr. Bruno. Record page 2401, where it says, this is the district court's judgment. Considering the record, the cause of Mr. Bruno's injuries may have been known to him when his ailment ceased post-removal. May have. That's a very weak formulation. And I don't think that's drawing an inference in favor of Mr. Bruno. He goes on to say, however, the doctor's recommendation of the removal of the device, again, Mr. Bruno did not request it come out. He acceded to his doctor's recommendation that it be removed, coupled with his recurring physical ailments, conclusively put him on notice of a link between Biomet's device and his damages. The court then cites the case of Jenkins versus Bristol-Myers for the proposition that a doctor's concerns may be conclusive and dispositive proof. But the critical distinction, Your Honors, is in that case, the doctor expressed concerns about the medication that was causing that patient's problems. The doctor here never expressed concerns about this device, so we think Bristol or Jenkins is distinguishable. But in any event, the judge makes the logical leap that by recommending that this device be removed, that by implication conveyed the doctor's concerns to Mr. Bruno. I have to tell you, Your Honors, I think that is a breach of logic and law. I don't think I think saying perhaps this needs to come out is not, given the course of what he had experienced and that everything else had been tried. I in no way see that as an implication that
Was there any other reason they took it out? Any other difficulty he was having with the device being in?
No other difficulty, Your Honor. I mean, it was all infectious related, and that's why an infectious disease was.
It was taken out solely with the belief and the hope that the infection would be resolved once it was removed.
Correct, and I think there are myriad explanations why this device could have been causing him problems that have nothing to do with a suspicion that there was something endemically wrong with the device. For instance, people who get organ transplants, sometimes the body just rejects the organ. There's not a manufacturing defect in the organ that's being transplanted. So ultimately, the judge finds that the ailments coupled with the doctor's actions put him on notice. I disagree with that, but even if I could allow myself to imagine, Your Honors, that Mr. Bruno was put on notice and he had begun to investigate, I think it would have been a futile exercise and a fruitless exercise. After all, we know, and again, we know for sure, that Biomet doesn't know or send out a letter until September 25th, 2019. So either they notified the public when they knew it, or they knew it earlier but chose not to notify the public until September 25th, 2019. But in either event, there's been no showing what my client would have found had he exercised reasonable care in investigating the facts of his cause of action. So with that, Your Honor, we would ask this court to consider finding that contra non volentem does in fact save Mr. Bruno's claim, or in the alternative, remand the case for the district court with instructions that this issue be delivered to a jury to make a determination of whether what Mr. Bruno did based on his age and education and intelligence, based on the information he had available, whether it was reasonable for him not to know or not to have constructive notice of his claim until he received actual notice of his claim in that letter from Mr. Paulette. Thank you, Your Honors.
Mr. Woodruff? Mr. Nolan?
Good morning, Your Honors. My name is Pat Nolan, and I'm here on behalf of the appellees, Zimmer and Biomet, in connection with this case. Your Honors, appellant Mr. Bruno wants to rewrite Louisiana's contra non volentem doctrine to avoid the fact that he filed this action well beyond the 1 year after the injuries he claims in this matter first manifest themselves. And these injuries were significant, and in fact, he characterized and alleged them to be severe injuries starting as early as January of 2017. And yet, through a course of various treatments, as the court is aware in this record already, there were a series of treatments that Mr. Bruno underwent. And yet, at this point, he did not take any action to further investigate this claim.
What was he supposed to have done once his doctor told him that the issue, the difficulty, was due to something other than the device?
Well, the record is not as clear as I think Mr. Bruno's counsel made out. There were certainly episodes in the medical records which suggest that Dr. Doolins was looking for sources for this infection and hypothesized that it was coming from other locations beyond the device. But ultimately, in November of 2018, and that is the really critical period of time here, in November of 2018, Dr. Doolins ultimately decided and encouraged Mr. Bruno to have the device removed. And that is, we would submit on behalf of the police, that is the critical period of time. And that is when, at the very least, Mr. Bruno had constructive knowledge that he had a claim and had a theory.
Well, you have two things happening, as I understand it, and of course, I invite you to give us anything specific from the record that will assist us in deciding this. But you have two things that are happening. First, his doctor says this problem is not caused by the device itself, although other things relating to the fact that the device was there, apparently. And then, secondly, the doctor says, so let's remove the device.
That is true. And
So again, I mean, how is he on further notice by the fact that the device is being removed if he's been told by trusted medical authority that the problem is not with the device?
Two things there, Your Honor. First of all, the doctor's opinions and his recommendations in this matter evolved as the record shows. And ultimately, the record sites that I would point to the court to are in the undisputed statement of facts that Biomet submitted in this matter that were not contested, by the way, by Mr. Bruno, in which both Mr. Bruno and Dr. Doolins discussed the various options and then elected to proceed with the removal of the device and the washout and with placement of the temporary cement impregnated prosthesis or the replacement product. That's the first part of that, the answer to your question. The second part or answer to your question is that after that was done, the infection symptoms that Mr. Bruno was claiming in his shoulder that had been lingering for 22 months had essentially dissipated, tapered off, and disappeared. So those two facts in and of themselves, and the district court, I think, was correct in this area.
The district court was correct in drawing an inference from those facts. It sounds very
well.
The argument is that your argument really takes away the jury's role in the summary judgment question.
In the question, this can be resolved obviously as a legal question. It's not just an inference. There was constructive notice at that point for Mr. Bruno to do something, further inquiry. In other words, what the case law repeatedly says is, was he excited in terms of doing a further inquiry? And that is really what the district court, that is what the appellees are suggesting is appropriate here. And those kind of cases have been resolved over time. The Taxatier case in particular, and the Jenkins case as well, were both resolved as a matter of law. And the courts there both held that the plaintiff in that case did not do enough to investigate the cause in a timely manner. The prescription period runs when the constructive notice begins. And our suggestion here is on November of 20.
I assume that the word constructive here means that someone introduced that there are certain amount of facts that would compel this outcome. You have constructive knowledge because fact A, fact B, fact C, you put them all together, and you don't draw that inference. That sounds very easy, like a jury question.
Well, the case law, especially Taxatier and especially Jenkins, suggests it does not need to be a jury question, and in fact can be resolved as a matter of law. And in Taxatier, for example, the question was it was a hair loss case involving plaintiffs who sustained hair loss that was permanent in nature, and they did not bring a lawsuit for over 6 years after
I understand, but I go back to Judge with my colleague's question with regard to the doctor-patient relationship and the educational level of this individual. That matters. And who better to judge the knowledge of what kind of obligation we put on a person who does not have a high level of education, trusting his doctor. That seems to me like that's a great question.
Well, there's no question that the doctor-patient relationship is important, but here, again, Dr. Doolins ultimately came around and implicated the device and certainly performed a major surgery on Mr. Bruno to remove the device. So that in and of itself, that action speaks louder than any words and is suggestive of the fact that the device, at least at that point, was a possibility, a source of the infection. That's all that is necessary to begin the constructive notice time period to begin for prescription purposes. And that is our suggestion, is where his obligation lies in November of 2018 or shortly thereafter. Mr. Bruno, the record is clear that Mr. Bruno took no action. He took no action at any point in time until he contends that he received notice of this recall letter. And that was back in 2019. But our suggestion, the district court also, I think, was proper in terms of deciding that the constructive notice began long before, and the obligations associated with constructive notice began long before that time.
Counsel,
At one point, the doctor was saying that he thought the problem was from a suture abscess and not the device. And so that's what the patient is hearing. And then the fact that the doctor says, so we're going to remove the device, presumably that means once you remove the device, there are no more sutures, no more suture issue. How does that put the patient on notice that something is wrong, not with the suture, but with the device?
I think it's because of the sequence of events, Your Honor. So the suture hypothesis was early on in treatment. In fact, I believe it occurred in 2017 that Dr. Doolins commented that it could be a superficial infection arising from the sutures themselves. So this was a full year before the removal of the wholesale removal of the device. As I indicated before, the record seems to suggest that Dr. Doolin's opinion of the source of the infection evolved over time. And so by November of 2018, he made the decision to remove. Now, this was also met with resistance from Mr. Bruno. The record is suggestive of that too, that Mr. Bruno was not interested in having the device removed. Only after further counseling with Dr. Doolins did they proceed to do that. So I think that is a suggestion there in the record, a fairly clear suggestion in the record, that Mr. Bruno had come around to the notion that the device itself was the source of his infection. And it may not be actual knowledge. We're not suggesting here that he had actual knowledge that the device was causing his infection, unlike some of the cases that are cited in these briefings. But it certainly is constructive knowledge that he needed to do more. He was on guard that he needed to take further action to look into this cause. And this was back in 2018, so over a year before he filed suit. Our suggestion that this recall letter that he continues to rely on for the starting of the prescription period is essentially irrelevant for purposes of whether or not the doctrine of contra non volentem actually applies. It should have applied far earlier.
Counsel, let's, if you would, tell us which facts between November 1st of 2018 and September 25th, 2019, which facts are supported by the record that would start the prescriptive period?
So certainly the fact that the discussion between Mr. Bruno and his doctor in the week prior to the removal of the device, that would be in the week prior to November 18, 2018, is a critical fact. The second most important fact is the dissipation or reduction in his treatment with his doctor for this precise malady, this precise claim, this infection in his shoulder. He did not treat over 4 months after the procedure. He did not treat any further with Dr. Dulins for this. Those are.
That's in both the deposition of the doctor as well as the plaintiff?
It is. It's also in the petition.
Okay.
It's in the petition as well. These facts are relatively undisputed in terms of the suggestion that these fact pattern in the treatment is really not disputed. It's in the submissions that have been filed in summary judgment.
Anything else before September 25th, 2019 that you would argue, if those didn't do it, is there anything else that you think on our timeline would do it?
Well, I would submit this, Your Honor, and this is something I haven't spoken to yet, but I would submit that, frankly, given the extreme pain that Mr. Bruno was experiencing, frankly, from the very beginning of the implantation, there is support in the law and support in this record that Mr. Bruno should have been on constructive notice well before even the November 18th procedure. In other words, that he had continuous pain. And while there were statements by his doctor that suggested that it could have come from other sources, the law is clear that, especially with the Taxotere case, the Jenkins case that we've cited, and the Avery case, that there does not need to be a precise source or knowledge of a precise source of the injury in order for constructive notice to begin. Only that there is an injury, certainly he had one, and that he is then obligated under the law, under contra non volentem, to then begin to seek further inquiry. And this further inquiry certainly would have revealed the device. We know this, frankly, by virtue of the fact that he has since submitted expert opinions, whether they're valid or legitimate expert opinions. He was certainly able to get expert opinions.
So you're saying he should have gone beyond, I'm talking about before the removal, that because of his pain, he should have gone beyond consulting with his doctor?
Certainly there is a suggestion because of the length of time that he was experiencing. This was over 2 years of time that he was having problems, severe problems according to his petition, that suggests that he had issues with this precise issue of the implant and the infection that continued to linger over and over.
So the answer to Judge Engelhardt's question is yes, he should have gone beyond his doctor?
Yes, the constructive notice period could very well have begun earlier than November 18, 2018. So yes, because of the nature of the injury, the nature of what he was claiming. But at the very least, as sort of a bookend, clearly the removal of the device is a bright line aha moment when Mr. Bruno should have had constructive notice and should have engaged in further. I think that the district court, Judge Guidry, was not totally precise, but in this particular case, it doesn't necessarily need to be. We do not necessarily need to have precision, because we do know that in all events, looking at the totality of the record and the totality of the treatment, that Mr. Bruno was clearly outside was prescriptive, essentially, by filing when he did. I will also point out, and I got a little bit off track, that the notice, this recall notice that Mr. Bruno is apparently relying on is actually not supportive of the idea that the device caused the particular infection that Mr. Bruno is claiming. In fact, the recall notice, a careful reading of the recall notice, says that there is no enhanced risk of infection associated with the recall condition at issue. So to the extent that Mr. Bruno is relying on this recall notice, it is almost misplaced in a way, and it's almost an after-the-fact type of rationalization for why he filed suit when he did. Again, the point is that constructive notice began well before this notice, this recall notice that Zimmer Biomet issued. And with that, I think I don't have any further comments.
The letter said, quote, "The devices were subject to cleaning processes that could result in elevated levels of bacterial endotoxin and residual debris remaining on the devices."
Right. Bacterial endotoxin is different than the bacterial infection that Mr. Bruno was suffering. Bacterial
And
endotoxin.
he's supposed to know that, I guess, right?
Well, I think the point is that he is certainly by that point in time supposed to have already investigated whether this device was the source of his infection. But the nature of the recall and the recall condition, bacterial endotoxin, is markedly different. Bacterial endotoxin is not a bacteria. It is a residual cell debris that is on the device itself. And it doesn't cause infection. It is simply potentially, in some of these devices, it could potentially cause an inflammation. But it does not cause the condition that Mr. Bruno was suffering from, which was a endobacterial cloacae infection that was repeatedly discovered and found in his shoulder from January of 2018 through the time that the device was removed in 2018. And so my point is that I believe that this notice is essentially an improper way. It's unlike the notices that were received by plaintiffs in the Taxotere case, where there was an explicit link between the condition and the device itself, or the pharmaceutical at issue. There was explicit notice to them from third parties. This is not what this particular notice does. And with that, I will take any other further questions, or we will urge the court to affirm the district court.
Thank you, Mr. Nolan.
Thank you.
Mr., is it Ginart or Ginart? You can take.
No, my uncle used to say Ginart, and my dad said Ginart, so I answer both.
All right.
May it please the court, opposing counsel. What we have is an infection case. Every time you have an operation, you go into a hospital, you're told infections can happen. You sign consents, infection can happen. This isn't just a run-of-the-mill infection case. That's what everybody thought. When you ask about what the doctor said, his deposition has been attached to the defendant's motion for summary judgment. On page 24, this is his own words, infection is a risk of any surgery. So what did Mr. Bruno find out when he went back to the doctor time and time again with recurrent infections? That's what he was told. And you do not have any knowledge that it was the Biomet comprehensive reverse shoulder prosthesis that introduced the bacteria into Mr. Bruno, correct? Correct. And do you not have any knowledge that it was a Biomet comprehensive reverse shoulder device that caused Mr. Bruno's infection, correct? Correct. This is what Mr. Bruno was hearing from his own doctor. And so Mr. Bruno was informed of the risk of infection through the form and signed off on it. Yes. He talked about serious drainage. Didn't even know if it was infection. It was maybe a seroma with a collection of fluid. Did you believe the wound was infected at this time? No, he was unsure at first. Then it goes, the infection was due to a skin contaminant. Is that correct? Correct. Typical skin flora. A common bacteria for a skin infection. Yes. This was a superficial issue, and he might have had a reaction to the visceral sutures. The parts of the components that we could see and palpate felt normal, and there was no evidence of infection. That's when he did the debridement early on, well before they took the shoulder out. So he checked the prosthesis at this time, said he didn't think it had anything to do with prosthesis. Well, at least he wasn't looking at that. And you would expect a loosening if there was an infection. Said, yeah, there wasn't any loosening. And that was of the component itself. So this made you believe that the infection started from something other than something external from the capsule, the prosthetic. Yes. And then he talks about the reason for taking it out. It's very, very difficult to clear infections once they're into a prosthesis. You know, judges, I look at this as kind of common sense. My mom had me mop and clean my floors. If I wanted to vacuum that over there with that table, in order to get it clean, what would I have to do? I'd have to move that. If I vacuumed that room and didn't move that sofa, my mom wouldn't have been too happy. Why? Because you can't get to it. By implication, taking the shoulder out should have made him know something. Yeah, that the infection got under this, and they got to get that out to get at that infection that keeps coming back, goes away, comes back, because it's hidden underneath there. That's the implication that you get. That's the only implication that you get. When you look at the letter itself, the September 25th, 2019 letter, in the second paragraph, it says, Zimmer Biomet recently completed an assessment of that supplier following awareness of the warning letter. So in September of 19, they had recently completed their own assessment. So, Mr. Bruno, the air conditioning man is supposed to know before Biomet knows? And I'm not saying Mr. Bruno's unintelligent. If this was an air conditioning case, he would have been right on it. This is not an air conditioning case, Judge. This is an adulterated product that nobody could see the adulteration, was put in, and a common infection occurred. And what's funny is they're arguing right now, don't listen to the doctor, because Mr. Bruno should have found out. Later on at the trial, they're going to be telling the jury, hopefully later on at the trial, they'll be telling the jury, listen to the doctor, this couldn't have affected it. And so that's the position that we're in. And when you go ahead and look at this letter saying they recently completed their assessment, and then it goes on to say that the cleaning process could result in elevated levels of bacterial endotoxin and residual debris remaining on the devices, can cause a local tissue reaction, inflammation. There is not an elevated risk of infection. So they tell Mr. Bruno there's not an elevated risk. Well, he's not quite that dumb. He reads this and he says, you know what? I need to go see an attorney.
Your time has expired now, Mr. Ginart. Thank you.
Your Honor, thank you very much for this oral argument.
The case is under submission.